Good evening. Welcome to Indian Polity session. So we'll have a discussion on High Court. In the previous classes, we have discussed very detailed about the Supreme Court of India. Just similar to that one, we have the High Court at the state levels. And the points are almost similar. So we can conclude this in a very fast manner. Because you have the complete background of the Supreme Court, it becomes easy for you to understand this concept of High Court. So let me straight away open the document and talk to you regarding this High Court. Look at this. Articles 214 to 231 of Part 6. Part 6 of the Indian Constitution talks about this. Part 5 talks about the Union Executive, Union Legislature and the Judiciary. That is the Supreme Court. And when it comes to the Part 6 of the Indian Constitution, it talks about the state executive, state legislature and the judiciary at the state level. So straight away I'm going to the High Court now. So we are having a discussion. Look at this. These are the articles in the Part 6 of the Constitution that deals with the independence, jurisdiction, powers and procedures of the High Court. Supreme Court is apex court, we know this, and the High Courts are below the Supreme Court. And when it comes to the High Court, it occupies the topmost position in the judicial administration at the state level. Under the High Court, again, there is a system of the subordinate courts. They are called district courts and the other courts. Look at this. When it comes to India, the concept of this High Court is not at all a new one. In fact, it was originally started in the year 1862, long back. And there were 3 high courts that were set up in India. And the first high courts were set up in Calcutta, Bombay, and Madras. So these were the 3 strategic areas during that time. British was there in India. And these high courts were set up. Later, within a very short period of time, another high court was also set up in Allahabad. So that is the beginning of the journey with respect to high courts. The Constitution of India provides for a high court in each state, but the 7th Amendment of 1956 Act authorized the Parliament to establish a common high court for 2 or more states. That is the reason in India right now we have 24 high courts, but the number of states is 29, meaning the number is not matching. Meaning for every state we don't have a high court. But the Constitution originally said if we have a state, we need to have the High Court. But the 7th Amendment made it very clear that authorized the Parliament to establish a common High Court for 2 or more states. Right now in India, we have 24 High Courts. Okay. And there are 3 common High Courts in the country. Look at this next one. Out of the 7 union territories in the country, Delhi is the only union territory with High Court. Remaining all union territories are attached to other High Courts. But Delhi is a NCT, National Capital Territory, and there is the only union territory with a High Court. And the Parliament is empowered to extend or exclude the jurisdiction of a High Court. So this is a most possible question in any examination. Every High Court has got its own jurisdiction. But what is the jurisdiction of that High Court? That will be decided by the Parliament from time to time. That's the reason why either you can extend the jurisdiction of a High Court or you can exclude the jurisdiction of the High Court. Everything will be decided by the Parliament through the law. Next one, the security of tenure is provided to the judges of High Courts by the Constitution. This means the judges of the High Courts can be removed by the President only in the manner and on the grounds mentioned in the Constitution. Look at this. I would like to share some points with you. In the previous class, when I was talking to you regarding the Supreme Court, we have discussed various points with respect to Supreme Court. So as of today, there are 31 judges in the Supreme Court. Everybody is appointed by the President of India. In the similar manner, There are so many judges working in various high courts, but the number of judges in the high courts vary from state to state. Means that all depends on the interest of the President of India. Hence, the number may be either increased or the number may be decreased. That's the reason why Constitution has not fixed the number of judges in the High Court. Okay, but when it comes to the Supreme Court, I told you one point: the number of judges in the Supreme Court will be increased by an act that is passed by the Parliament. Parliament is empowered to alter the number of judges in the Supreme Court. Okay, but when it comes to the High Court, the number will vary depending on the interest of the President of India from time to time. Right? That is number one point. Number two, all the judges in the High Court are also appointed by the President of India. But since 1993, just like the Supreme Court, even for every High Court, the recommendations are being made by the Supreme Court Collegium. I told you what is the Collegium in the previous class. Let me not repeat this again. So the Supreme Court Collegium used to recommend, and that was accepted by the government. But very recently we have seen the Constitution has been amended and a new body is going to be created called National Judicial Appointments Commission. Of course, that is going to be headed by the Chief Justice of India, and that body is going to recommend who should be appointed as the judges of the Supreme Court and also as the judges of the High Court. Just like the Supreme Court judges, High Court judges will also have the certain qualifications. The term is fixed. The term is fixed in the sense the term is not fixed for the judges. It is the retirement age that is mentioned. As of today, a judge of a High Court retires at the age of 62. While talking about the Supreme Court, I said it was 65. But with respect to the judges of the High Court, they retire at the age of 62. And when it comes to the removal, I explained you how a judge of the Supreme Court is removed. During that time, I made it very clear the same procedure is followed even for the removal of the judges of the High Court. Everything is common, almost everything. Is it okay? Now, let me open the document and share some information with respect to this High Court. The judges of the High Court do not hold the office during the pleasure of the President. Meaning the concept of pleasure of the President is not coming into the picture. They retire only after attaining the age of 62. Now look at this. So far, how many judges of High Court have been removed? Answer is 0. No High Court judge has been removed so far. This is what I have given in the next line. Look at this. This moment. No High Court judge was removed so far in independent India. Except during the financial emergency, the service conditions of the High Court judges cannot be varied to their disadvantage. The salaries, allowances, and pensions of the High Court judges are determined from time to time by the Parliament. Very important point. High courts are present at the state level. Salaries and allowances are paid by the state, but how much is the salary, how much is the allowance, how much is the pension, everything will be decided by the Parliament from time to time. Kindly remember one thing: salary and other allowances are paid by the state governments, but when it comes to the pension, pension is always paid by the central government. Just remember these points. Next one. I'm moving further. Look at this. The salaries, allowances, and pensions of the High Court judges and staff, as well as the administrative expenses, are charged on the consolidated fund of the state. While talking about the budget, I explained all the points very clearly. What is the meaning of the charged expenditure? It means they are not discussed in the Parliament. They are discussed in the Parliament, but they are not votable. Voting is not permitted, only discussion is permitted. In the similar manner, the actions and the decisions of the High Court cannot be criticized and opposed by anybody. If so, this may be considered as the contempt of the court, and on that particular reason, the court may punish any person or any authority. Look at this. The CJI appoints the officers and servants of the Supreme Court. Hence, there will be no interference by the executive. In the similar manner, the Chief Justice of the High Court is permitted to appoint the servants for the High Court. The Parliament cannot curtail the jurisdiction of the Supreme Court, but the Parliament can extend the jurisdiction of the Supreme Court. Important, there is no area in India which is not coming under the purview of the Supreme Court. Parliament can keep on extending the jurisdiction of the Supreme Court if it wants, but Parliament cannot reduce the jurisdiction of the Supreme Court. Look at this. Qualifications of the judges of the High Court. We have seen in the previous class regarding the Supreme Court judges. When it comes to High Court judges, similar points. Must be a citizen of India, number one. Should have held a judicial office in the territory of India for 10 years. Meaning, anybody who worked as a judge in any court at the district level can be appointed as a judge of the High Court, or should have been an advocate of a High Court for 10 years. If you look at this particular point, please see here very clearly, this point we have also used even for the Supreme Court, meaning anybody with an experience as an advocate of a High Court for 10 years, he can be appointed directly as a judge of the Supreme Court or a judge of the High Court. Kindly remember very clearly, these are the questions which are very frequently asked in the examination. And while talking about the Supreme Court, we also said that the President may appoint a distinguished jurist to the Supreme Court, but that provision is not available here at the High Court. Look at this. Please note, there is no provision for the appointment of an eminent jurist as a judge of the High Court. The Constitution has not prescribed a minimum age for the appointment of a judge of the High Court. There is no minimum age. Anybody who is coming under this qualification, I am highlighting on the screen, the person can be appointed as a judge of the High Court. Look at this. Appointment of the judges. The judges of the High Court are appointed by the President of India, and the Chief Justice is appointed by the President after consultation with the Chief Justice of India and the Governor of the concerned state. Look at this. In case of common high courts for 2 or more states, the governors of all the states are consulted by the President. Look at this next one. When it comes to the oath, we have already seen with respect to the Supreme Court judges, the oath of office is administered by the President of India. With respect to the High Court judges, though they are appointed by the President of India, oath of office is administered by the Governor of the concerned state. Look at the point that is highlighted. The person appointed as a judge of the High Court has to make and subscribe an oath or affirmation before the Governor of the state. Next, look at this. In his absence, in the absence of the Governor, some other person is appointed by the President will perform the same. Next one, look at the term. When it comes to the term here, the Constitution has not fixed the tenure of the judge. When it comes to the holding the office, he holds the office till he attains the age of the 62. Look at this. The question regarding the age is to be decided by the President of India in consultation with the CJI, and the decision of the President of India is final. Look at this. Originally, the retirement age was 60 years, but through 15th Amendment of the Constitution, the retirement age has been increased to 62, and another discussion is going on. This is 62 years is going to be increased to 65 years. Next one. When it comes to the salary, privileges, leaves and pensions of the Supreme Court are determined by the Parliament from time to time. In a similar manner, even, I think here I should write the so-called High Court, please. High Court are determined by the Parliament from time to time. And right now, the salary of the High Court Chief Justice is 90,000 rupees, and that of other judges is 80,000 rupees. Everything is decided by the parliament. Look at this. But they are charged on the consolidated fund of the state. We know what is the meaning of this. Now, when it comes to the pension, kindly remember this very, very important point. The pension of the High Court judges is charged on the consolidated fund of India and not on the state. Look at this. Salaries are paid by the state, but the pension is paid by the central government. And just like any authority, if whenever a judge wants to submit the resignation letter, he can submit the resignation letter to the President of India. Next, when it comes to the removal here, I need not explain you so detailedly because I have already explained you, but this notes contains a detailed explanation here. He can be removed through a procedure called impeachment. He can be removed by the President on the recommendation of the Parliament. He is removed in the same manner like that of a Supreme Court judge. There are two reasons. One is the proved misbehavior, or second one is the incapacity. Look at this. The removal procedure can be initiated in the Lok Sabha or in the Rajya Sabha. We know all the points. If it begins in the Lok Sabha, first of all, 100 members must sign. The notice will be given to the speaker. Then the speaker will constitute a committee with 3 members. They will conduct an inquiry and the report is submitted back to the speaker. Again, that will be discussed in the so-called the Lok Sabha. And who are the members? Here, we know this point. These are the 3 people. And later, after discussion in the Lok Sabha, if it is voted by the special majority, then the scene will be shifted to the Rajya Sabha. And in the Rajya Sabha, if it is accepted by Rajya Sabha, again with the special majority, then the president will be removing the concerned judge. In the similar manner, if the procedure begins in the Rajya Sabha, same procedure, but the only difference is that it should be signed by 50 members from this Rajya Sabha. Because it is from the Rajya Sabha, obviously the Rajya Sabha members will be submitting a notice to the chairman of the Rajya Sabha. If it is signed by a minimum 50 members, that will be accepted by the chairman of the Rajya Sabha. Again, he will constitute the committee. That committee will conduct the inquiry and the report is submitted back to the chairman. Same story. Again, there is a discussion on the floor of the Rajya Sabha. Voting takes place. If it is passed by special majority, it will be shifted to the Lok Sabha. If it is discussed and passed with a special majority, then the president will be removing the person. President will be removing the concerned judge. But kindly remember, certain attempts were made to remove some judges, but so far no High Court judge has been removed. Very, very important point. Kindly remember this. So far, no High Court judge has been removed in India. So this is the same story, same points, and all the points are given in the notes in our site, that is kalyansir.net. Can you look at this? Look at this, the transfer of the judges. The judges can be transferred from one High Court to the other High Court by the CJI. Next is the National Judicial Commission. Since beginning, there was a demand. Of course, this is the old matter. It has been already accepted and the constitution amendment was made. This is an old story. And today we have a National Judicial Appointments Commission. But if you want, you can have a look at the miscellaneous points. High Court is the highest court of appeal. High Court is the protector of the fundamental rights. The High Courts are vested with the power to interpret the Constitution. In the absence of the Chief Justice of a High Court, the President can appoint a judge of the High Court as an acting judge. The Chief Justice can request a retired judge of the High Court or any High Court to act as a judge. Same points, just like that of the Supreme Court, the points are same. And the High Court is acting as the original jurisdiction, and the High Court has the power to the writ jurisdiction. We know all the points here. Whatever the points I spoke to you regarding the Supreme Court, every point is also applicable. Is that okay? Look at this. When it comes to the High Court, is also considered to be a court of records. What do you mean by this? The judgments that are given by the Supreme Court will be followed by the High Court. In the similar manner, The judgments that are given by the High Court are followed by the lower courts. Again, the judicial review is the power of the High Court to examine the constitutionality of the legislative enactments and executive orders of both the central and the state governments. Look at this. The judicial review is needed to uphold the principle of the supremacy of the Constitution and to maintain the concept of the federalism, and also to protect the fundamental rights of the citizens. Same points, every point you know very clearly. The words judicial review are not mentioned in the Constitution. The High Court has the power to review its own judgment, no issues. But when it comes to the interpretation of the Constitution, Supreme Court has the ultimate authority. Clear? Next. So apart from this, at the lower level, we also have something called subordinate courts. Look at the points, simple points again. These subordinate courts are also called the lower courts. The articles in the part 6 of the Constitution, 233 to 237, they make the provisions to regulate the organization of the subordinate courts. The Constitution ensures the independence of these courts. But the one thing is that Supreme Court and High Court judges are appointed by the President, whereas the District Court judges are appointed by the Governor in consultation with the High Court. What are the qualifications? Look at this, simple. The person should not already be in the service of the central or state government. The person should have been an advocate or a pleader for 7 years. And the person should be recommended by the High Court. Anybody with this qualification can be appointed as the District Court judge. Look at this. The postings and promotions of the District Court judges in a state is made by the Governor in consultation with the High Court. The appointment of other judges other than the district judges is also made by the Governor of the state after consultation with the State Public Service Commission and the High Courts. You might have seen this in every state, you have the public service commissions. Other than district court judges here, this examination is conducted by the State Public Service Commission. And after conducting the examination, so these remaining members, they are appointed by the so-called the Governor, right? So here, this is a very simple topic. It is simple because we have explained the Supreme Court in a very detailed manner. And kindly read both Supreme Court and also High Court from our notes. And if you have any doubts, you can just get back to me. Okay. And so this is the end of this High Court. I'll stop at this stage and we'll meet tomorrow with a new topic. So thank you so much for being with me this evening. See you. Good night.